to the surprise of no one, Mr. Hilligus continues in his sort of bizarre legal theories in Missouri.
Thank you.
Fellow Attorney with the division.
Thank you.
Good morning, Your Honor. Silverberg, alternate public defender's office on behalf of Mr. Handte.
Thank you. Good morning, Mr. Handte. Good morning. All right, so when we met a month ago, we talked about a month delay or continuance, not delay for the sake of delay, but a month continuance to allow defense to review the file, get up to speed, look at the pending motions, see if they're ready to add, what to be ready to move forward. Also, at that time, we might have some insight as to Mr. Hilligus' status, on whether his extradition went forward or not, where it is, and then also to set this case for trial. I also, in the interim, did receive from Mr. Handte a filed notice of psychological evaluation. I may have the title wrong, but identifying some issues that he has, and not to be disrespectful to anything he has going on with regard to his physical or mental health, but he's now represented by counsel. He's not to file things on his own. So I struck it, right? I struck it as pursuant to local rule and pursuant to the court having control of its docket. But then he refiled it. He refiled it again, and I believe I struck it for a second time. And I want to make sure we're all on the same page here, that the defendant is not to file anything on his own. He has counsel. He's not authorized to file things on his own behalf. And I think the first time I struck it, I indicated that if counsel felt that there were issues there that ought to have been brought to the court's attention, and you could move forward with that or not. So we can't have Mr. Handte filing things on his own in this case, and I'll continue to strike it. And if he does it again, I'm going to likely set it for an order to show cause why he should be sanctioned or held in contempt. But I don't want that. And I know he doesn't want that. He just wants whatever he's got going on to make sure it gets to the court's attention. All right, those are my preliminary thoughts. Let me start with Mr. Stege. Are we ready to set this case for trial? Do you have any update on Mr. Hilligus? Anything else that the court has identified?
Yes, update on Mr. Hilligus. Governor Sisolak, I believe 2 weeks ago, signed the governor's warrant. To the surprise of no one, Mr. Hilligus continues in his sort of bizarre legal theories in Missouri, as reported to us. So we know that is on the desk of the governor of Missouri. The updates we're getting from people in Missouri is that we expect that off the desk of the governor of Missouri quite shortly. Within the week.
Anticipating that the governor from Missouri will allow Mr. Hilligus to be extradited back to Nevada?
Yes, and I can say I've never seen a governor of another state not sign the Constitution and the interstate agreement on detainers. They always sign.
All right, so what does that mean with respect to a trial date?
So it means we can expect to have Mr. Hilligus shortly back in Nevada. The holidays complicate things, but by the end of the year, I would expect Mr. Hilligus to be in the Washoe County Jail. It's also reported that the proceedings are complicated by Mr. Handte's repeated phone calls to the jail and other people in Missouri with bizarre claims that they have no right to detain him.
Wait, if they have no right to detain Mr. Handte or?
To detain Mr. Hilligus, sort of advocating in really a way that's not proper to, particularly jailers and people of that group on behalf of Mr. Hilligus. And again, this case is characterized by this bizarre and unfounded legal theory.
Well, I had previously directed Mr. Handte to have no direct contact with Mr. Hilligus while Mr. Hilligus was on pending warrant status,
Yes.
direct or indirect. Now, is he on pending warrant status now? Not really. The warrant's been served.
Right.
And so,
Yeah, so that's concerning to the state, also concerning to the state. And I want to sort discuss this in relation to the unnecessary, improper filing of that psychological evaluation. We are seeing Mr. Handte back at these sort of internet news sources, giving what he's calling interviews, but broadcasting out on the internet about this case. Now, the court's well aware of the gag order in place and the bail, the circumstances leading up to the bail situation with Mr. Handte. That coupled with some other communications that we are receiving from Mr. Handte, just for the tone and nature of them are troubling to the state. And we have been on this case quite a long time, but even from a distance, it appears to be sort of increasingly, I'll use the word concerning, sort of Mr. Handte's mental state. Even including in the hallways before court today, just sort of very vociferous, loud cursing by the defendant.
Well, he wouldn't be doing that because my deputies would have, if they saw it, they would have told him to not use that language inside the courthouse or step outside.
Right.
So,
But in the hallway, we are understaffed in deputies, I submit. In any event, so it is my intention to bring that issue before the court, one being the gag order, two as it relates to the conditions of release, and three touching on this question of sort of competency and the issue of sort of bizarre and paranoid thinking. So that sort of to decide for the time being.
let me, before you go further, let me tell you what the notes are. The state may ask the court to revisit its prior gag order, revisit its prior decision on a possible gag order with respect to Mr. Handte's communications about this case.
Right, yeah, sort of enforcement of the gag order that the court has already issued.
To take a look and see if what he's done, based on whatever you're going to
Yes.
file, it was over that line.
Yes. Now, I'm also aware,
I also wrote down to reiterate, no filing while you're represented, and three, at some point, we are going to talk about the trial date. Four, we're going to talk about whether Mr. Handte is doing something that directly or indirectly violates the prior admonition not to have any contact with Mr. Hilligus. Five, to tamp down, this is part of the gag order, tamp down media or social media contact with respect to issues on this case. And then finally, concerned by the state that Mr. Handte's behavior or paranoia or activities is indicative of somebody who may, I don't know, this is not the word you use, but may or may not be in a position to proceed to adjudication at this time.
yeah, and I'll be more direct on that. In social media, Mr. Handte is reporting the death of his cat, which he attributes to people involved in this case. Sort of exactly revenge for the death of his cat. So I hope to do that through motion work, unless it becomes so urgent, I would do it in a different.
What about the trial date?
Trial date. So I am comfortable. I think we ought to start thinking about and coming up with trial dates, because I know there are probably some issues with the Hilligus matter, but if we don't, given the sort of the premium placed on trial dates in all of the departments, but in this department as well, so securing time on the court's trial calendar seems like the right thing right now.
Thank you. I'm sure we'll talk again for sure. All right, a lot to digest, Mr. Silverberg, and in any particular order, you can address some or all of the issues we raised, and anything else you'd like to bring to the court's attention.
Your Honor, it was a 30-day pause to get caught up on a few things. Meanwhile, I'm hearing the state bring up all kinds of issues against Mr. Handte, none of which is in writing, none of which I'm prepared to address, and I find it concerning that the state brings this up at this hearing without really giving any notice whatsoever that he's going to bring that up. And none of these issues, competency, that's not a state issue. That's my issue, whether I think my client is competent or not. That is a defense problem.
Well, let me just stop you there, because with respect to Mr. Hilligus, the court sua sponte had concerns, and was the one that ordered the psychological evaluations, which then he failed to appear for, and then here we are.
Certainly the court can order that.
Sure.
I understand that, but I can tell you as Mr. Handte's attorney, I have no issues with his competence.
Okay.
The state has problems with his personality. The state has problems possibly with the fact that Mr. Handte takes a very strong stance about these charges, and I would too if I were in his shoes. I don't know what the state thinks, how people should react under these circumstances, but there's nothing on paper before us to address. If you want to set a trial date, which I thought that's what we were going to talk about today, and Mr. Hilligus, that's what I'm prepared to do. I'm prepared to set it for trial. I'm prepared to wait another 30 days to see if Mr. Hilligus gets here and has his counsel, however the court would like to proceed.
Well, he doesn't have counsel now, right? He's self-represented.
Mhm.
And so when he's returned to Nevada, somebody will let me know, and very likely I'll appoint counsel on his behalf to assist him through the process of getting back here, evaluations, response to opinions, things like that. But that's just going to take some time.
No, I understand that, Your Honor, and it's my understanding the state wanted them tried together. So it seems not so efficient to set a trial date, but we're still waiting to see what's going to happen.
Well, unless we send it out for the summer or the fall.
But that's where I'd be
We
setting
have a
it anyway.
placeholder.
Be it with just Mr. Handte or together, I'm not going to be available until the fall.
How do we inspire your client not to file anything by himself? Because next time we have this discussion, there's going to be consequences that are going to be unpleasant for him, and I don't want that.
Your Honor, I think the message is received. I think the problem was, at least what he tells me is that the timing of it, he thought it was before my actual appointment, but it wasn't.
You were appointed on the record, you made an appearance on the record.
Right.
I think later you filed, or maybe recently, a notice of appearance formally, that you've been his attorney since the point in time you appeared for trial, and said we would agree that your appearance here would constitute a notice of appearance.
Yes, so, Your Honor, I think he understands. I'm sure he was frustrated with me because the last month I've been getting ready for a trial, as well as any number of other things, as we all have. So, given a 30-day pause, I was not paying a lot of attention to Mr. Handte. It's his only case, so I understand his anxiousness and frustration. But I also put it in context. I don't jump to the conclusion that he somehow has a competency issue because he's anxious about his case, or is anxious to talk about it to the extent that he can. And those sort of gag orders should be very narrowly construed. But if the state
What he's filing though is, mental health exams, right? Psychological evaluation. So it's not as though he's filing something else, unrelated to that. So that's.
I'll talk to him about it, Judge. I don't think there's going to be a problem in the future, and I'm ready to set it for trial if that's what you want to do.
What about previously, the court ordered Mr. Handte have no direct or indirect contact with Mr. Hilligus while Mr. Hilligus was on pending warrant status. He's now no longer on that status. He's on a different status. He's in custody on the warrant and apparently fighting extradition. He'll be extradited or not, and then we'll see where things go. But in terms of the no contact, if once Mr. Hilligus' competency is established or not, and once he's back here, they're co-defendants in the trial. They can talk. They can collaborate on issues of joint interest. I'm not trying to tamp down on that, but I wanted to make sure that nothing that happened here in Nevada affected the ability to bring Mr. Hilligus back, have him evaluated, and hopefully proceed to adjudication. So I need to give some thought to whether whatever's happening through Mr. Handte or others, at Mr. Hante's request, or trying to help Mr. Handte out, or communicating with Mr. Hilligus, and whether the court should step in. But right now, I haven't really thought about it because it's the first time hearing that might be an issue.
Yeah, it's the
Assuming
first
that-
time hearing of it as well, Your Honor, and I would object to even broaching the subject until the state can put something concrete in writing that we can verify.
Okay, fair enough.
Those allegations.
Okay. What about, so did you do, in this last month, have you had a chance to review the file, look at some of the motions that are pending at some
Just
point?
very briefly, not to the extent that I could address them. What we are going to be addressing is the ankle monitor. I'll be making a motion about that on behalf of Mr. Handte, but no, I haven't had the chance, Your Honor, with every other trial and prelim and everything else that's going on as again, my understanding was it was a 30-day pause and nothing was going to be happening of great importance until then, while we waited to see what was going to happen with Mr. Hilligus. So no, I'm not prepared on any motions.
Okay, before I hear back from Mr. Stege, anything else you want the court to know at this point?
No, thank
Do
you.
you want to just have a chat with your client, make sure there's nothing he wants you to say? I don't have a mute button or a white noise button, so if you're going to talk, please do it quietly.
No, Your Honor, thank you.
Okay, Mr. Stege, anything else you'd like the court to know?
Starting with the end there, it's concerning that, I mean, the court said, let's look at motions, and that did not happen. That's concerning to the state. Also concerning to the state, and I'll say it maybe in a more vernacular, it hurts my ears to hear that we're talking about a fall trial date, right, given the delays in this case. That's not, I don't think, acceptable. And on a legal point, I'm intimately familiar with this issue of competency, and I will say it strongly, it's completely unsupported that the question of competency belongs to a defense attorney alone. I mean, Mr. Silverberg's office is successive counsel on a published decision in which I was involved, where the court, it was the appellate court, ruled that it was error for the trial judge not to suspend proceedings, irrespective of the defense counsel's failure to bring it up or desire not to bring it up. And I will anchor it even more directly in the statute, which says, if doubt arises, right, it's not.
So here's what I took Mr. Silverberg's comments to mean. He didn't mean legally neither the court, prosecutor have the ability to raise it. That's not what I understood him to say. The gist of it was that he feels like he would be in the best position to evaluate his client based on their more frequent interactions. So that's the takeaway here. But we're all well aware that if the court or any interested party has concerns about the ability of the defendant to understand the charges, assist in his own defense, communicate with counsel, things like that, they can raise that and the court can take action.
Yes.
Let's talk about the trial date. What I want to do is, in fact, I'm ordering this. By this time next week, counsel R2 have contacted the court clerk and set this matter for trial. 8 court days. We'll start on a Monday, and I'll make sure we block out to the middle of the following week. This case will be set to begin no later than September 30.
Thank you, Your Honor.
Now, when you set that, once we get that date, please set 2 other dates. So we'll reverse engineer the motion to confirm about 2 weeks before the trial is supposed to begin. And a week before that, a final pretrial conference where any pending and yet undecided motions will be argued. The goal will be to rule from the bench, and based on the court's rulings, counsel can factor those in, and Mr. Handte, to whether to confirm trial or not. So again, set the trial, 8 days, a couple weeks before, set the motion to confirm, and a week or so before that, final pretrial conference. And we'll block out a half a day for the final pretrial conference.
Thank you, Your Honor.
Yeah. We'll set this for another status hearing in about a month, sometime middle of January. That'll give enough time for, if there are any motions to be filed by the state or any party based on issues that the state believes have now arisen, or issues with respect to pretrial supervision status of Mr. Handte, or anything else. That'll give time to file it, respond, reply, submit it, and I'll take up at this hearing any then pending motions, including motions that have previously been filed. So I'm gonna actually, let's move that out to about 45 days from now, because we have 3 holidays in between. So I'm not gonna set that date now. When you call in for the trial date, please set a status hearing. Give us a couple hours so we can handle it. Pardon me?
So there'll be 4 dates we're actually setting.
4 days.
Status,
Yes.
a motion to confirm.
Yes.
A pretrial conference and trial.
Yes, I'm in a murder trial that begins sometime in January, 2 weeks, I think. Yeah, make sure we're on either side of that, so I have enough time to prepare.
Thank you.
That's all the court has right now, Mr. Stege.
But only that if, upon the return of Mr. Hilligus, we can, I imagine we'll have to have some date on that, and we counter both defendants at that time.
Yes, yes. And likely, what will happen with Mr. Hilligus will be simply the court-appointed counsel to help him from that point forward.
Yeah, it's an interesting question because he went through the forensic canvas, but I just pick that up when we get there.
This is different though, because has to do with his competency, and so he really can't, at this point, make an informed decision whether he wants counsel to help him with to challenge, fight, object to, whatever he's gonna do, so we'll handle that issue when it arrives.
Thank you.
All right, that'll conclude this hearing, thank you. Thank you, Mr. Handte.
Thank you, Judge.